As part of the SEC Ripple case, Judge Torres has been provided with a new document that was submitted by the SEC. Ripple was reportedly awarded a fine of $12.6 million as stated in the document. Some influential people on social media have hypothesized that the Securities and Exchange Commission (SEC) is currently seeking to reach a settlement with Ripple, although this is an absurd statement. As part of the civil fraud action, an agreement was reached to pay a total of $4.5 billion. In the first place, the Securities and Exchange Commission has made a request that Terraform Labs and its former CEO, Doan, pay a total of $4.5 billion in civil penalties and discouragement prejudgment interest. 2. The judge in New York who is presiding over the lawsuit must still give his or her approval before the settlement can be finalized. 3. and Terraform Labs would be permanently barred from buying and selling crypto asset securities. This prohibition would apply to both companies. In response, Ripple submitted a new filing in which it requested a reduction in the fine that was imposed by the SEC in the case that involved the terrorist settlement. While they are appealing for a charge of $10 million, the Securities and Exchange Commission is arguing for a fine of roughly $2 billion. This amount of $10 million is not new. Likewise, Ripple's argument is not. As part of the proposed consent decree, Terraform will be required to pay a total of $420 million in civil fines and $358 billion in deterrence. This is the most crucial thing to keep in mind. Approximately 1.27% of the defendant's total sales figure of $33 billion is represented by this amount. This amount is being requested by the SEC on the basis of direct witness testimony of losses sustained by investors. In addition, the proposed cooperation agreement stipulates that Terraform must pay a civil penalty of $420 million, which is equivalent to about 1.7% of the defendant's total sales turnover of $33 billion. The most essential thing to take away from this is that the Securities and Exchange Commission (SEC) is making ludicrous requests for fines, and it is difficult for anyone with even a half-brain to fathom the magnitude of the SEC's absurd demands. The civil fines that Terraform Labs is required to pay total $420 million. As well as $3.58 billion in dissuasion, as indicated in the proposed consent order by the SCSCSC. Approximately 1.20 cents of his legal penalty is equivalent to the $33 billion in gross sales that the defendants have achieved. In addition to seeking that Terraform pay a civil penalty estimated at $420 million, around 1.7 of the defendants are bedolling, or being asked to pay $33 billion in sales. Investor losses have been cited by the SCSCSC, which has referenced direct witness testimony. Thus, to summarize, a recent decision taken by the Securities and Exchange Commission (SEC) to reach a settlement with Ripple in the SEC Ripple case has made it feasible for the ongoing legal conflict between the two companies to be resolved. It is clear that the Securities and Exchange Commission is dedicated to protecting the interests of investors and maintaining the integrity of the financial system, as evidenced by the tough approach it takes to penalizing companies like Ripple. In response to the letter that was sent by the defendant Ripple Labs, which Ripple claims provides support for its decision to deny the SEC's remedy motion, the Securities and Exchange Commission has responded in the case of CC versus Terraform. The SEC is proposing a settlement that, according to Ripple, has little bearing on the decision of which are remedies to pursue in a court of law. Because of these factors, the Securities and Exchange Commission (SEC) has repeatedly declared that the court is required to approve the settlement in accordance with the applicable law. On the other hand, as noted in the remedies reply brief provided by the SCSCE, Ripple is not agreeing to any of these relief opportunities. The Securities and Exchange Commission (SEC) asserts that Ripple continues to behave in a manner that is analogous to the acts that first resulted in the violation, the capacity of the judge to evaluate whether or not Ripple's current Odell sales violate any laws is called into question as a result of this. The attorney for the member of the XRP community, Bill Morgan, has made it clear that the Securities and Exchange Commission (SEC) is dissatisfied with Ripple for its conduct and is now requesting that Ripple pay more than $2 billion. Since July 13, 2018, also known as XRP Victory Day, this has given birth to reports that Ripple is going to either toss out the $2 billion charges or settle for $12.5 million with the Securities and Exchange Commission. Ripple's actions have left the attorneys for the Securities and Exchange Commission (SEC) feeling unsatisfied. Because of this, they believe that they were overpaid in the first instance, and as a result, they are demanding that Ripple pay more than $2 billion. In light of the fact that the so-called billion-dollar charges are not a fair and reasonable method of establishing the amount of penalties required to deter an unquestionably affluent defendant, traders have begun to bet that Ripple will soon pay the SEC $12.6 million in settlement. This would result in the dismissal of the so-called billion-dollar allegations. that refuses to recognize or acknowledge its violation of the securities laws and continues to enrich itself by engaging in unlawfully similar conduct that initially the attorneys for the SEC have been called whiny because they disagree with what Ripple is doing and are upset about their loss on July 13th, also known as XRP Victory Day from the previous year, at the extent to which they are demanding that Ripple pay more than $2 billion shows how resentful they are about this situation. The Securities and Exchange Commission (SEC) has been subjected to criticism for its original response to Ripple Labs' letter as well as its subsequent response, which has been criticized for being excessively aggressive and frightening. As a result of the proceedings taken by the SEC, there has been speculation that Ripple is going to reach a settlement with the SEC for a sum of approximately $2 billion, which is equivalent to $12.6 million. The absurdity of the Securities and Exchange Commission's decision to impose a fine of $12.6 million on Ripple, a company that has been accused of violating the Civil Penalties Act, is highlighted in the accompanying summary. When compared to the SEC's assertion that the penalty is merely 1.27% of gross sales, the $10 million that the corporation was awarded in the CC's case cannot be considered significant. When compared to any other case that has ever involved cryptocurrencies, the SEC is requesting a punishment that is 20 times more severe. Ripple sent a notification to the court. This argument is supported by statistics, and the attorneys for the Securities and Exchange Commission (SEC) responded to Judge Torres with a gimlet that is, at best, regarded to be devoid of any rationale for the statements that are significant. Instead of dividing the $420 million settlement penalty by the total revenue of the corporation, which is a significantly lower revenue figure that results in the 11.7 figure that they boast about, they chose to divide it by 11.7. As part of the SEC's request, Judge Torres should split the revenue by the total revenue of the corporation that represents violative activity. The summary also places an emphasis on the SEC's attempt to perform a useless and arbitrary mathematical equation rather than a genuine comparison. In order to establish a fair comparison and determine the normal manner in which the SEC punishes businesses, it is necessary to make a reasonable comparison between the amount of the penalty and the entire gross income of the company. The penalty dollar amount is then divided by the total gross income of the corporation according to Ripple's calculation. Following that, it applies the same logic to circumstances that are equivalent or much worse, cases that are more heinous. As a result of the fact that Ripple's behaviors reveal a pattern of behavior that is typical of SACs, this is the aim behind them. The summary continues by noting that the fine ought to be distributed among the 5 restrooms that are located at Ripple's headquarters, which is another evidence of the lunacy of the company. After then, the Securities and Exchange Commission advocated for Judge Torres to divide the $420 million penalty amount by the total number of restrooms, which was 5. As a consequence of multiplying the result by 100 in order to calculate the percentage, 8.4 million are acquired for each bathroom. In a nutshell, the decision of the SAC to impose a fine of $12.6 million on Ripple is seen to be absurd and does not correspond with the goals of the Civil Penalties Act. This is an extremely important point to keep in mind, as the SAC's argument is backed by a comparison of apples to apples to apples, and the summary does not provide any reason for their choice. The overview comes to a close by showing the absurdity of the SAC's decision to fine Ripple $12, which is merely 1.27% of total sales. In the conclusion of the summary, the importance of understanding the justifications of the Securities and Exchange Commission as well as the potential consequences of its actions is underlined. This random statistic, which is based on the recommended penalty for Ripple by the SEC, is designed to trick the judge into thinking that the sentence is acceptable and just, or at the very least, that it is less severe. The Securities and Exchange Commission has made the decision to split the $420 million fine by a lesser quantity in order to acquire a bigger